Good evening, everybody. I hope you are all doing well this Tuesday evening. I know we normally do this on Wednesday, but we had to do it on Tuesday this week. It's been a kind of a strange week. Obviously, a lot of crazy stuff going on. We had that hurricane last week. I hope those of you, I know people in Asheville, North Carolina, really got hit hard. So if you were in the path of the hurricane and you're still recovering, I wish you the best. Here in Atlanta, we didn't really have much. We had a little bit of flooding in some low-lying areas, but really not much other than just a little bit of wind and a lot of rain. Not too bad. And then let's see what else is going on. We had a number of notable deaths. Dikembe Mutombo, the basketball player, Pete Rose, the all-time hit king, passed away. Just again, kind of a strange week. There's war going on in the Middle East, which is very concerning. Regarding Mutombo, just a brief story about him. He lived in Atlanta. He played for the Atlanta Hawks and stayed here. And I used to work out in the same gym as Mutombo, and I would see him there, at the gym working out, and he would ride the elliptical and do weights and so forth. Obviously, a big guy, 7 foot tall, and he was very friendly to everybody who walked up to him. I never really bothered him. I always felt like, people that were always getting bothered, I wasn't going to really do that. So I just, I would nod at him or just wave at him sometimes. But one day I read in the newspaper where he had funded some program or a hospital. I mean, he was always doing all these philanthropic things. And so I went up to him and I said, Dikembe, I just want to let you know, I saw what this project you were doing was in the newspaper, and I just really have been a long time fan of yours, not just as a basketball player, but all the things you did. And he looked at me, said, "My name is Jonathan Ginsberg." He looks at me, sticks his hand out, he goes, "I'm Mutombo." Like, obviously, I knew, you don't see a lot of 7-footers walking around. We had a nice chat. He was very, very friendly, very approachable, just a great humanitarian, just a real mensch in every way, shape, and form. And he died of brain cancer. He was 58. I knew people who had seen him not too long ago and said they had no idea. So I think he was just very quiet, dignified guy. I think he had adopted his late brother's children. I mean, he was just a really good guy. So a real big loss, to the worldwide community. He was quite the humanitarian. And of course, Pete Rose, kind of a different type of career, but obviously a great hitter. So just kind of a strange week in a lot of regards. So anyway, let's kind of get moving on to Social Security. Oh, and one more thing I didn't want to tell you about, if you weren't aware of it, there was a really funny, I guess it's kind of like a rant by this comedian named John Oliver. I'm going to put it in the notes or in the comments here. If you have not seen this, it's definitely worth a watch. Let's see here. There we go. A lot of the Social Security listservs, everybody was talking about it. Basically, John Oliver is sort of this very sarcastic, cynical British comedian. He's got a show in the United States, and he just talks about just the bizarre world of Social Security disability, and how it's just the bureaucracy of it, and how it puts people in a terrible way, the long waits and the ridiculous decisions and so forth. And so if you haven't seen it, it's if you're living it, it probably won't be quite as funny, but it's just really pretty hilarious just how he just skewers Social Security. So if you get a chance, it's worth watching. So anyway, that all being said, let's go ahead and answer some questions here. Rick Torres, and I'd answered him offline, but he said, when you turn 62, does SSDI switch over to retirement? And the answer is no, they switch it over at full retirement age, which would be 65 or 66. So you're not going to get switched over at 62. In fact, if you file for disability and you turn 62, you can elect to take early retirement, so you have money coming in. The danger is if you're not approved for disability, you're stuck at the lower figures. At 62, you get about 75% of the full retirement amount. So if you file for disability, file for early retirement, you get money coming in. If you win, they'll bump you up. And the back pay will be the difference between the early retirement and full retirement. So let's say that your early retirement was $1,500 a month, full retirement's $2,000, you would get $500 a month for however many months it took to make a decision in your case. So it's a good strategy if you want money coming in. Now, it can be a bit of an issue to get an attorney. And, I have to look at these real carefully when somebody reaches out to me and they're getting early retirement, because if the difference between early and full is $300 a month, and let's say the case takes, a couple of years, it's not very much money. So you might be looking at, $4,000. The attorney's fee on that would be $1,000, which again is nothing to sneeze at, but generally speaking, the fees in disability cases are going to be 3,500, 4,000, 4,500 when all is said and done. So some attorneys won't touch them if you're already getting early retirement. I think if you, on the other hand, a person at 62, it's going to be an easier case. So a lot of times those cases get approved. So I kind of take on a case by case basis, but be aware that if you are getting early retirement and you reach out to an attorney for disability, you may have some attorneys tell you they're not going to do it because there's not enough money in it. So just for whatever that's worth. All right, St. Louis Grant, who is a regular here, he notes, I assume it's a he, that COLA, cost of living, adjusts Social Security payments every year if a case is opened and is on remand from district court. The award amount include COLA increases for all the years. Yeah, I mean, basically the amount of the benefit you get, they treat it as if you were actually getting the benefit. So if the benefit you were getting was subject to the cost of living increase, you would get that. You don't get punished for having to wait because they're taking so long. Jim Tusky, getting closer to his hearing on November 21. When will his attorney start prepping him? He's never met him or spoken to him. Well, that's a concern. Although, again, in this practice area, it's not terribly unusual because these cases take a long time. And, I'll just be straight with you. You got to do this in a volume basis to make it financially viable. So you're going to deal a lot with paralegals and so forth. I try to do as much interaction with my clients as possible, whether it's by video or by call, things like that. But it's you're not going to get a call from your attorney every week. I'll just flat out tell you, it's just not economically viable to do that. But I would say that you have a hearing. It's the beginning of October. You should hear from your attorney by the end of October, 1st of November. You should be getting calls from the staff people to make sure everything is updated, to get your medication list, your work history, that kind of thing. And I think if you're not hearing from them, get on the phone and call and say, look, I got a hearing coming up in 6-7 weeks, and I want to go ahead and get started on this. And what's the schedule for my prep? And that's kind of also why I do a lot of this by video. I have all these videos out there that I make available to my clients about how to prepare for your hearing, because that in combination with the live call is a good way to do it. Good question. SS says, how do I recommend addressing mistakes with the consultative evaluation report and the DDS findings? For example, the CE doctor, consultative doctor, said that SS could bend over and touch the floor, and then said he refused, incorrectly said that SS refused to bend over. What I would tell you is, after a consultative evaluation, write down all the things that happened, all the things that concern you. Because what we can do as attorneys is, at the time of the hearing, the judge will ask the attorney, do you have any objections to any of the exhibits in the file? And at that point, if you've not already done this in a pre-hearing brief, you would say, or the attorney would say, Your Honor, on October 5th, 2023, the claimant had a consultative evaluation with Dr. John Smith, and the reports at 14F. However, the claimant reported to me that some of the indications, some of the notations in this report are inaccurate. And specifically, the claimant did not refuse to bend over to try to touch his toes. In fact, the claimant, because of back issues and knee issues, cannot bend over and touch the floor. The CE doctor spent no more than 5 to 7 minutes with him, did not touch him, refused to look at MRI reports that he brought with him. We would therefore ask Your Honor to give this consultative evaluation report little to no weight. And I typically do that in writing. You can also do it verbally. Judges have the right to weigh evidence, and they could say they're going to take the report, the CE report, and that will be, what they use to make a decision in the case, deny you or even approve you. But I think that if you raise those issues, I think the judge would have to at least address that. And there's a couple of different ways. Theoretically, you could ask the judge for the right to cross-examine the consultative doctor, or ask the judge to send him out for another consultative. But you can object to the findings, you can object to the weight that would be given to it, and you can object to the amount of time that was spent, and why that report should be given little to no weight. Whether that would hold up on appeal, I don't know. I mean, I think that's going to really depend on, a lot of other factors. But I would certainly say that, if you felt like the report was inaccurate and you were shortchanged in terms of telling the doctor what's going on, I would definitely let your lawyer know it. But I would say, and I tell my clients, when you go to a consultative, write down what happened, good, bad, or indifferent, right away, so it's fresh in your memory. It's really hard to think back what happened in October of 2023 or in October of 2024. So you want to definitely be very, diligent about doing that as quickly as you can. And in fact, one of my colleagues, Michael Liner, who's I think in Cleveland, he actually has a form. He sent it to me, and I need to find it, where it's kind of a CE report that he gives to his clients to write out, what happened. I probably should start using something like that. And I think it's a good way to, really keep track of what the problems were. And a lot of these CE reports are pretty useless. I would tell you that the judge, in your case, certainly understands that these consultatives are marginally, valid at best, but the judge may or may not choose to, listen to the argument that I should be given less weight. G.I. Jose, Joe. The judge has a 46% approval rate, denied, bias, probably cherry picking, still waiting on a letter, appeals counsel, here you come. I would say this, that the average, if I'm not mistaken, the waterfall chart said the average approval rate nationally is about 48 or 49%. So 46% is not, ridiculous. I mean, you could judge with a 30%, 25%. I think that's more ridiculous. But I think if it's a, 46%, that's not terrible. You'd rather be 55 or 60%, but 46% does not mean you're going to get an unfair decision. Realize when you appeal to the appeals council, you're not getting another bite at the apple, in the sense that the appeals council is not going to revisit the evidence. They will accept the judge's, interpretation of the evidence unless it's clearly wrong. The exhibit says that the claimant has a patellar fracture of the right knee, when in fact it's the left knee. Things like that. There could be errors like that. More often, it's that there's conflicting evidence, and the judge does not explain why he or she disregarded this line of reports versus that line of reports, or that the judge found that you had a medically determinable severe impairment, but did not include it in the functional capacity, the question to the vocational witness. So it gets a little technical, which is why, by the way, what I do when I get, people reach out to me all the time, I got denied, will you look at my case for appeal? I read it over, jot down what I think is incorrect, and then with the potential client's permission, I'll send it off to, there's 2 or 3 lawyers that I work with. That's all they do is appellate work. And I'll send it off for kind of another opinion. And if the other attorney agrees with me that there's something going on here, one of us will draft a decision, the other will look at it, then we'll file it. And then with the idea that, I would be the attorney doing the retried case if it's remanded. But, going to the appeals council does not mean that the evidence is going to be looked at by another judge, the way your hearing judge looked at everything with a clean slate. You have to show an error of analysis is really what you're looking for. And so again, the appeals council work is kind of a different animal. 4 conditions not listing level. I thought doctors would keep it going if you can. Okay. They need to update the wording of the website. Step 4, non-medical should pop up with the judge's decision. 3 days, no emails, logged into denial, talks about. So I'm not sure, Joe, if you're saying that you got a denial and you just can't get a hold of it, or or the online site is wonky. I don't know, but you'll certainly get it soon enough. Rodney, one of our clients. Hello, Rodney. How are you doing? L. Brown, October 1. Today is October. Can you believe October 1 already? That's just amazing to me. It just seems like just yesterday that we were, it was springtime. It was February, March, and now it's October. Um, I don't know. Just, it just seems like the older you get, the years go by faster and faster and faster. I have a 1-year-old granddaughter, just turned 13 months today, as a matter of fact. And, a year ago she was kind of a blob, and now she's taken some steps and she's talking a little bit, and she's, very aware of what's going on. And it's just amazing. So time goes by. Sheila's one of my clients. How are you doing, Sheila? I hope you are doing well. Nadania with a smiley face. Hello. Longshoreman. That's another. I think that's something else that El is talking about. Another crazy thing going on. There's a longshoreman strike. I know it's in the Northeast. I saw online, but that could really affect the supply chain in terms of us getting things, everything from groceries to, clothing to other things that you need. So hopefully that gets resolved. It just seems like things will kind of rock along, and then just everything just kind of goes crazy. It's kind of weird. You just sort of have to. We're so used to everything kind of working. You flip the switch on, the light goes on. You order something on Amazon and it comes a day later. And when some of these things break down, supply chain breaks down. It may take a couple of weeks. It's just kind of nuts. I have an Apple Watch here, and the battery went dead, and so I called Apple. First, I called Best Buy, and would you fix it? And they said, yeah, I could bring it in. So I go in. The guy's like, we don't fix them. We just sell new ones. Like, I'm not going to spend $500 or $600 on a new watch when I need a $100 battery. So I called Apple. They put me through 45 minutes of questions about when it wasn't working and how long. And finally, at the end of the conversation, I'm like, look, I got to go. He's like, well, we'll send you a box. Just send us in the old one and we'll send you a refurb. Okay, so I'm like, why didn't you tell me this 45 minutes ago? But anyway, I did that. I got it back today. Seems to be working okay. But, it's just pretty amazing that, you send something in like this. They don't even bother replacing the battery. They just, they have a system where they just refurb it. So we're used to just having things happen instantaneously. You go on Amazon, it'll be there tomorrow. They're going to have drones deliver stuff. So, when things happen that slow it down, it's a real issue. It's a real issue. Okay. Joe asked, how do you handle post hearing doctor's appointments? Could those be appointments to be referenced to the appeals council? Generally not. I think that the record is closed at the hearing, and the only time that new evidence really is going to be relevant would be if it had existed before, and for some very good reason it was not included in the original file. That you could show that the doctor wouldn't cooperate, or that nobody knew about it, or it wasn't available. You could submit it. But I think that, I don't know that the appeals council is going to look at new evidence. Now, when if you get remanded back, then at that point, you can submit new evidence. But I believe, if I'm not mistaken, and again, I don't, this is part of the issue. I don't deal with, some of these appeals council procedural issues. But my understanding is that the record's closed at the hearing, and the appeals council will only deal with the record there unless there's something that existed but was not in the record before. And that may be wrong about that. Hey, Wolf, good evening to you. How are you doing? Trish Wade, another regular. How are you doing? Sheila says, Jen is my paralegal, left us a message. Jen doesn't normally work on Mondays, so she gets back on Tuesdays. We also, and again, just craziness, we were using this system in my office called HONA, which is like a texting system. And the goal of it is to update our clients with just it's a combination of canned messages, just we're still thinking about you, as well as personalized messages. Well, the problem is it's set up where on the first of the month, everybody on the system at a certain level, in terms of the initial recon, wherever they're at, they get a message. So we get, probably 30 or 40 text responses the first of every month, and the 15th of every month, because things go out automatically. And I probably need to change the messaging to say this is an automated message. But that's also an issue that we have to probably. I may not continue with this because with HONA because it's just too. I think it gets people too anxious about it where they get an email or a text and then they have a lot of questions, which is fine, but when everybody asks questions at the same time, it kind of backlogs us a little bit. Okay, but Sheila, I will make sure that Jen is aware of your message. In fact, I will email her right now. Or I'll just make a note. How about that? I'll make a note for Jen to call Sheila. Jen, call Sheila. Okay, I'll make sure that happens. All right. And Michelle Smarts says, if after a hearing, the judge has completed the appeal, the case claim has been sent to the field office for non-medical review, is that a good sign? So what Michelle's getting at is the case goes to the judge makes a decision, and you see in your online status that it's going to the field office for a non-medical review. Generally speaking, that is a good sign because a non-medical review is where Social Security looks to see if you have earnings, because obviously the issue in a disability case is you don't have the capacity to earn an SGA $1,550 a month in 2024 at that level. Well, if they find out that you in fact have been working in 2024, that might make a difference as to whether the judge would approve your case. Now, I had a very interesting conversation with the Social Security claims rep the other day. We were talking about a case, and this guy was actually very, very easy to work with, very pleasant. And he was telling me that they use I think he told me it was Equifax or Experian. They have a product that basically tracks people's employment. So Social Security has a subscription, and so they can, they log into this product to see whether you are working. And they may send you some other forms as well. But what they're concerned about would be, let's say, we're now in October. Let's say that somebody, went to work, in August of 2023. They didn't file their tax returns yet. They got an extension, and they've also worked in 2024. Well, they may be a year and a half of earnings that are not reflected in Social Security's record. So the non-medical review would be to look to see, are there any earnings? Is there something different? If it's an SSI case, do they have any assets that have come into their name worth more than $2,000? So that's why it's usually to make sure that everything works, everything is in good shape before they issue the approval. So generally speaking, Michelle, that would be a good sign. Eric, what's up? Thanks for your help. Hoping to see Sadie. Sadie is, actually, my wife took Sadie for a walk. So I have not heard them. I'm downstairs in my home office. I've not heard them come by, but if come back, I think she probably went to my daughter's house and having dinner over there or something. So if Sadie should come downstairs, I will have her come in. She gets a little she likes attention, so she sees me, she wants to play. I'm like, I'm on a live stream, no kid to tell. And of course, dogs don't really understand the concept there. Okay, I think you're talking about saw the John Oliver video. It was pretty awesome. I mean, he's talks about there was like this old Social Security video using mimes, talking about how Social Security works, and it was just, I mean, some of the stuff, it's like, you've heard the expression, truth is stranger than fiction. That's kind of what this, I mean, it's just some of the stuff they do. They had at one point a sign language interpreter who wasn't really a sign language interpreter, that somebody came off the street and was just going like this, and it's just crazy stuff. So, Social Security is known for crazy stuff. Oh, and SS, thank you very much. I really appreciate the $4.99. Very much appreciate that. Will buy me a sandwich or at least half a sandwich at the deli. Okay. And they pay more to dependents. Elle, I'm not sure where you were coming from there. Maybe the longshoreman strike you're talking about. I don't know. Speaking of dependents or auxiliary benefits, let me talk about this a little bit, because someone had actually emailed me about that just a few minutes ago, one of my clients. If you have dependent children or other dependents, your benefit, let's say your benefit's $2,000 a month. Your auxiliaries are going to get, in addition to, they don't take away from what you get, in addition to what you get, usually about 25% of your benefit. So you're getting $2,000, your dependent or auxiliary may get $500. There's also something called a family max. So if you have 7 or 8 dependents, it won't be quite as much money. They would reduce the percentage. But if you have 1 or 2 children, minor children or children that are dependents, and you file for disability and you get approved, you will get not only your check, but you'll get a payment for your dependents. And that can make a big difference because, if you have 2 children and it's $500 a month each, that is an extra $1,000 a month. Now, there are attorney's fees on that. So not, again, if the maximum attorney's fee at this point is $7,200, you don't get more than, the attorney wouldn't get more than $7,200. But, if the underlying claimant's benefit was, let's say, $15,000 and the dependents was 20 or was 5, then the attorney's fee would be based on the $20,000 total lump sum. So, but auxiliary benefits are something definitely to explore if you have dependents. And sometimes you may have them for a period of time before while you're getting back benefits, and now they're, no longer dependents, but in 2022 or 23 they were. You can get that then, even if you're not getting it going forward. I think, and so I would tell you, if you have dependent children, make sure at some point to call Social Security and say, I want to make sure that my application does reference, and I've got dependent children, I want to make sure an application's filed for them, and you'll need their socials and things like that. Okay. Okay, Calvin asks a good question. If your pain management doctor is only giving you 14 pills for pain that are supposed to last 4 weeks, would it be okay to get pain pills from your primary physician to last you? I think you got to be real careful about that, because most pain management doctors ask you to sign a contract. They're under a lot of scrutiny, and the FDA, I guess it's the FDA, keeps them under a really, really tight leash. And so if there's any indication that you're seeking medications from different physicians, then you may get fired by your pain management doctor, and then that gets into your record, and that's going to make it really hard to win disability. So I would say I would probably call your pain management doctor and say, look, my primary care wants to give me X number of pills. Are you okay with that? And why? And if the pain management physician says no, I think you probably need to not do it. But I think you don't want to not, because if the pain management doctor gets wind that you're going to a different doctor getting pain medications in addition to what he has prescribed or she has prescribed, you're going to have a big problem, because when you get drug-seeking behavior as part of a medical record, really, really hard to win. All right, GC Styles. SSA is trying to get disabled persons back in the workforce. Why don't they do vocational assessments on the initial claim? Well, they do. Actually, what happens is, if you look at a file at the initial level, the state agency has a vocational consultant. They will, make an evaluation. They've never met you, of course. They're only relying on the record. And the adjudicator will write up, his or her interpretation of the medical evidence. The in-house vocational person will identify the past work classified under the DOT, Dictionary of Occupational Titles, and what the requirements are, both physically as well as, education and skills and so forth like that. Unskilled, semi-skilled, or skilled, sedentary, light, medium, or heavy. And then the adjudicator will make a conclusion. This person can return to past work, or this person cannot return to past work, but there are 4 jobs, or an in-house vocational witness identified this person could do, or 3 jobs typically. So they do it. Now, again, this is not the same as having a actual vocational rehab person, work with you. They don't do that, but they do an analysis as to your capacity. Now, I would argue that analysis is not nearly as thorough or as accurate as what you might get at a hearing. I've seen many cases where the vocational witness at a hearing comes up with different DOT titles than the one at the state agency, because the vocational witness at a hearing, will listen to you describe your work, and that might change how they describe the job. So But yeah, they do a vocational analysis early on. It's interesting. Sometimes that makes it in the claims file, sometimes it doesn't. So sometimes I can see it, sometimes I don't. But that's how they make a decision. Um, okay, JC Sports. You and your wife are divorced. You file for SSD. Going to get $1,900 a month. Told my kids get money too. How's my kids' money get spent? Does she get the dollar? Do I put aside for the kids? I think that's going to depend on that. That's actually a really, really good question, because there are a couple of things that come to mind here. One is, will you get credit for child support if you have dependent benefits or auxiliary benefits that go to your children? So let's say that you have a child support agreement that obligates you to pay, um, you know, let's pick a number, $1,000 a month for two kids, and now you have auxiliary benefits that are $850 or $900 a month. Does that mean all you have to pay in addition to that is $100? Maybe. I think that's something that you would talk to your divorce lawyer about. And in fact, that's an issue. It's just, I've seen courts go all over the map with that. Obviously, it's better if you can get an agreement with everybody that this money will be count towards that. But sometimes I've seen cases where judges in state courts say, no, it doesn't count. This is in addition to what you get. But obviously, when you get a child support order, it's based on your earnings, and this kind of substitutes for that. So I think that, given the amount of money you're getting from Social Security is a lot lower than you get from working, I think it's only fair to count it. But not every judge will do that. So I think you might want to look into that with your divorce attorney. And then the second point is who has control of it. I think it's whoever has custody, and that's really more of a domestic relations issue. There will be somebody who will be, if the children are minor, will be their representative payee. Generally speaking, the custodial parent will be the representative payee, but it doesn't have to be that way. Again, that is something that would be negotiated between you and your ex-spouse with your lawyers, or if you just a negotiation. And of course, I know what you're getting at is what happens if the ex-spouse doesn't use the money for the benefit of the kids, then comes back to me and says, I want more money. And that's, now we're getting into domestic relations. So I think that this is where, it wouldn't be a bad idea if you have an attorney to engage that attorney to work out some sort of a definitive agreement between you and your ex about who makes the decisions about the money, how it's to be counted in terms of child support obligations, and do you have any vetoes over what it's going to be used for? Let's say that you want to limit it to the doctor and the dentist and school, and your ex-spouse wants to use it for summer camp and clothes. But that's, again, more of a domestic relations matter. Social Security is not going to get involved in that, but that is something certainly that you could negotiate. And and I realize not everybody is going to be aware of this, but let's say that you kind of know you're going to be filing for disability down the road, or you think it's a possibility, and you're going through a divorce. It's probably not a bad idea to get that into the agreement, that should you file for disability, any auxiliary benefits would count to reduce your child support obligation, and that you want to be the representative payee for the minor children if you should go into disability, if you want that obligation. Being a representative payee it can be a real pain, by the way, because there's reporting and so forth. So but my point is that usually, if nothing is said, the custodial parent's usually going to get control of that, which again might make you unhappy, I would tell you. Your co-counsel on your case, make sure your attorney has all updated medical reports. Okay, I think what Elle is saying is you, as the claimant, are in fact, you've got to be your own advocate. And she says being co-counsel, that's not quite where I would put it, because that sort of suggests another attorney. But, you have to be an active participant in helping your lawyer update things. What we do in my office is we have, on everybody's email signature at the bottom, it says, if you've gone to a new doctor, have a change of medication, click here. It goes to a form that somebody can fill in, and it'll automatically send us an email with that updated information. But I think there needs to be some process in place where you can let your lawyer know about any new medications, any new medical treatment, and I think you need to establish a information pipeline so that if your attorney does, like we have My Case, which is a case management portal, people can upload things. We have, Hona, they can text us. My Case allows for messaging, things like that. Um, and of course our email signature file says click here to add a doctor. But I think you need to have some sort of a way to update your lawyer, whether it's by email, and maybe have, the subject matter would be, John Smith updated medical records. You want to obviously keep track of that, and you want to maybe even ask for a confirmation that was received by the, by the paralegal or legal assistant, because I think that Elle is very, very correct that if you don't participate in it, again, lawyers who do this, it's a volume and things slip through the cracks. And you don't want to be in a situation where you got a hearing coming up and you discover, with 3 weeks to go that, a year and a half's worth of records from your neurologist did not make it in the file. So Tracy says the payment sitter is slow with back pay. Yeah, they can be. There was a point in time where because I get my payments for attorney's fees, it's direct deposited into an account. I kind of have a separate operating account just for Social Security, and it tells me who the person was and so forth. And there was a period of time earlier this year where after the 15th of the month, there was no money coming in, nothing. It just didn't happen. Then the first or second of the month, I would get, several payments. So it can be a very slow in terms of back pay. Yeah, that's absolutely correct. So, you may have to start calling. It could be a real pain in the rear end to get them to release the money. I will tell you, because I know. Okay, so this is about dependents. The SSA will notify you, bring in birth certificates and explain everything, including how they'll get paid. This is again with a person who is going through or has gone through a divorce and has dependent children. So yeah, I think that it's all negotiable, but I do think that at some point you and the ex are going to have to get on the same page here. Okay, Rodney, good evening to you. Okay, JTLBZ. I've been on disabled adult child benefits since 1991, getting ready to turn 50 with a 7-year CDR. What happens if I turn 50? Well, first of all, the grid rules might go into play if you have physical limitations. So that's good for you. I think the odds of a review are reduced at 50. By the way, I did see in a blog, let me see if I can pull this up, that the CDRs that have been suspended by the commissioner will be started up again in October at some point during this month. So, that we had a hiatus of continuing disability reviews for 5 or 6 months in 2024. I think the fiscal year of Social Security ended on September 30th. So I think that the CDRs, unless it's again suspended, are going to start back up. It'll take them a while to get geared up, but certainly those of you in your 30s and 40s can expect to see more of those. I think when you're in your 50s and 60s, it's less likely. Social Security still has a personnel problem. And, in fact, some of the comments that on this blog were, that the people working for Social Security are like, how are we supposed to do that in addition to all other stuff we're way behind on? There's no answer to that, but just, it's going to slow the process down even further unless they put it again on a hiatus. Brooklyn Boy. Will a PhD that was earned 10 years ago be utilized during the application of the grids to add skills? I don't find in my experience that education is as big of a deal as a lot of people think it is. Work skills, transferable skills are more important. If you have a PhD in botany science or in, something that is, English literature from 1500s, I don't know that that's going to really make you more marketable in most jobs. So, it depends on what your PhD is. Now, and the other thing I will tell you is if you look at the way the grids are written, high school graduate or less or high school graduate or more. It doesn't distinguish between a 4-year degree, master's, MD, JD, any of that stuff, or PhD. So I think that, if you have let's say, a degree or a master's or a PhD in some sort of engineering that you have used in the work environment, and that you have and it's up to date, that could be an issue that would make you more skilled. But if it's earned 10 years ago in, you know, Renaissance, sculptures, it's probably not going to make that much of a difference. I think it's more important if you have a job where you did inventory, where you managed personnel, where you created policy papers or standard operating procedures. Those are skills that could be transferred easily to another job. But simply having a PhD from 10 years ago, I don't think that makes you that much more hireable. And that's ultimately what this is about: is, are you hireable? All right, JC Sports accessing dollar signs, and I think this is again where it's look, I know attorneys are expensive, but this is where a family law lawyer, divorce lawyer, can be really worthwhile to approach the other side with proposals and with where it's not emotional. I think one of the issues, I did some domestic years ago. I will never do them again, but when the individuals, the people who've gone through divorce, there's a lot of emotional anger, there's a lot of personal feelings, and the last thing that ex-spouses are going to want to do is cooperate with one another. And look, even lawyers can get caught up in that. But I think that if you have two lawyers who can sit down, especially if they know each other, and say, okay, let's come up with a way that it's fair to everybody. And if we can't get into an agreement, let's go in front of a mediator or arbitrator or something like that, or even a judge for a 30-minute hearing. Then you're going to get resolution, as opposed to just hard feelings of trying to negotiate directly with the ex-spouse. Elle says each dependent comes with a chart, and oftentimes we need to document spending. And what Elle's getting at is, as a representative payee, you have to document the spending that you've done. The problem is, who's going to really look at that? And Social Security is not going to be your enforcement agency. So if your ex-spouse writes down, after-school activities with the kids, spent $50. I don't know that you have the right even to demand an explanation as to what that is. Now, maybe you do in state court, but do you really want to be paying a lawyer to submit interrogatories and request for production of documents to your ex-spouse to figure out what he or she spent $50 or $100 on last March? So again, this is an area where I think negotiation between lawyers would be useful, or if you have to get in front of a mediator where you can kind of get it aired out, but it's not creating more hard feelings with the other party, that would be a better way to go. Because you're right, I mean, your ex-spouse may be seeing dollar signs, and have them watch John Oliver's little video to get an idea that there's not a lot of money in this. Okay. So Milestone Marcy says, I have my appeals case tomorrow, and I think that she means that she has a hearing tomorrow. So if that is the case, then we wish you the best, Marcy. I hope that it goes well. It is I know it can be a little nerve-wracking. I'm not getting this. There we go. It can be really nerve-wracking to go before a judge, but just remember that the main issue you want to talk about would be your capacity for work and why you would not be able to work reliably. And really importantly, go in with the idea that you've not given up, that you don't want to be disabled, you want to go back to work, that the idea of going for disability is a last resort for you, and that you would go back to work immediately if you got better. You never want to present what I call an attitude of entitlement. You always go with the idea, I'm a fighter, I hate this, I don't want to be here. I hope you answered your question. Now dependents are paid at what ratio? And again, I think that, generally speaking, if you look at, auxiliary benefits, it's usually about 25% of the main person. It's a calculation that equals 25% of the primary beneficiary or claimant's disability payment. But this family max will cap it. So if you have 5 kids, they're not going to each get 25%. It may cap it at the family max, whatever number that would be. And that's something you can ask them. What is my? It'll be actually. I think it's on that on your my Social Security statement. You can ask them what the family max is, and you'll see what the most you'll be able to get. Disability Digest, Brian's with you, but okay. Yeah, Brian, Disability Digest, Brian's a non-attorney rep, and he has a website called Disability Digest. And I've known Brian for years. In fact, I wrote a book called, Disability Answer Guide. He used to resell it, and then he'll call me to do hearings for him sometimes as a contract lawyer. In fact, we had one about a month or two ago where the case was clearly should be approved. I even wrote a little pre-hearing brief. The judge calls me before the hearing, is like, we don't need to do the hearing. You win. I'm like, okay. So I let Brian's office know we just won without a hearing. The client was thrilled. He was happy. And, everybody gets, we were able to move on. But Brian's a nice guy. Brian's a nice guy and does a lot. He's got a lot of programming for people in the disability world about, other resources available to him, housing and food and things like that. Trish, when doing a claim with a remote date last insured, which means that the insurance ran out, a year ago, 2 years ago. Boy, this is going to do it to me again, where it's going to start following me around here. Yep. I think when you wave your hand, it does that. I've got this camera that's got a mind of its own, but I can turn that off in a second. But anyway, what Trish is asking is, let's say that your date last insured was 2 years ago, 3 years ago. So that means, that your insurance runs out usually about 5 years after you stop working. So let's say that you stopped working in 2020. Your date last insured in most cases will be, let's make a better example. You stopped working in 2015. Your date last insured would probably be in 2020 or in 2024. So you have to prove, if you file an application, that you became disabled in 2019, 2020 before that date last insured. If you don't, then you're only going to be eligible for SSI and all the offsets that goes along with it. So date last insured is a really important thing to know. And again, sometimes you don't know it until you actually look at the file. But when you're dealing with a remote date last insured, do you list conditions that currently limit you or the condition you had 10 or 2 years ago? Questions seem like the present tense. I would, and what I think Trish is getting at is the application form doesn't distinguish that. So, it'll say, what are the 5 conditions that prevent you from working? Well, let's say that, your date last insured was 2020 and you developed a, herniated disc in 2024. So I would probably tell you to list the conditions that existed as of the date last insured. Then in addition to that, put the newer conditions, and maybe in parentheses, became problematic or became work preclusive in, 2021, 2022. Because realize when a judge hears your case, obviously he or she's going to be looking at the date last insured to make sure that your disability began before your insurance ran out. But for ongoing benefits, you got to prove you remain disabled. So just because you were disabled 4 years ago, what happens if you had a procedure and you got better, or, just by virtue of age, you got better. So I think that's definitely something to be aware. But I would do both. Let me shut this thing off where I can. I'm going to go blank for a second here. I got to turn. Oh, I don't have to even do that. I can just keep it on. And okay. So we got, it says, okay. So it shouldn't be moving around anymore. Okay. There we go. Yeah, it's interesting. I got to see if I can shut that off. I don't know if I can or not. It's ideal, if you're moving around, you're doing a presentation, you go over here and the camera follows you. But for my purposes, I don't want it to move. So PT LMA says, PT, physical therapist, stated you can only list 4 pounds, but this was not an FCE. Pardon me, this is not in a functional capacity exam. But after 18 PT appointments, no improvement due to broken shoulder and hardware. I think that you could argue that that is, in fact, a functional evaluation, that you've been limited to 4 pounds, which is going to put you at less than sedentary in terms of your residual functional capacity. Now, again, a judge could look at that and say, okay, you're 4 pound, you're limited to 4 pounds, and that's one opinion. This other doctor, the consultative doctor from Social Security, says you could lift 10 pounds. I have to decide which one I believe. I think you can make a pretty good argument that physical therapist would be a better resource, but I think that is functionally equivalent, if I can make a pun, of a functional capacity evaluation. It doesn't cover everything, but to the things that it does cover, I think that is very, very, very relevant. Okay, John says, I filed SSI. You mean SSDI, SSI? SSI is a type of disability for people with limited income and assets. So I'm not sure if we're talking about, make sure you're accurate, because a lot of people call social security disability SSI, very different things. SSI is one type of disability, SSDI is something else. But John filed SSI in July of 24, already have a hearing, set the initial recon, took 40 days. I can't even begin to explain why. If you're 100% VA disabled, that would speed it up. Why that would be the case, I've never heard of that before. I don't know. The only thing I would ask would be, have you applied before? Is this has it gone to the initial recon before? That may be why. If you're 100% disabled vet, that could be why. That'll speed it up. But I've never heard of it going that fast. That's great, but I've just never heard of it. Okay, this is about longshoremen. They make $155,000 a year, want a 70% wage increase. They make real money. I know nothing about longshoremen. I know that it can be a dangerous job. But yeah, I think they have a union that obviously represents them, and what they do is really important stuff in terms of making the supply chain work. So they certainly have a angle to ask for more money. Alice says hi. Hello, Alice. James McHugh says hello to Sadie. I don't think she's going to make an appearance tonight. I got the doors closed, but I will definitely let her know. She is she's a good dog. She's a big old thing, and she's very sweet and likes attention. But you couldn't ask for a better dog. Very smart. She's a real smart dog. She learns stuff real quickly, and she's very, very, very good natured. Okay, just Jake, you're in Gwinnett. Did you get, we had another crazy thing that happened. There was a lab leak from some chemical manufacturer, and chlorine gas, which is really dangerous. There was a cloud of it that was like in south of the city, probably 50 miles, I don't know, 40, 50 miles from here. But apparently it drifted over to Gwinnett County where Just Jake is. And it's pretty toxic stuff. It's really irritating to the lungs. If you have breathing issues, let's say long COVID, it can be really dangerous. A lot of those places have, they tell them not to leave the house, to, keep the windows closed. So that's another crazy thing, this, chlorine leak. So Jake, I hope that you didn't get hit with that. Jake is a retired police officer. Well, thank you for your service. Again, another very dangerous physical job. And I've heard some stories from clients who are police officers, just how dangerous it can be. And I'm glad we have police officers out there keeping things sane, because it can be an insane world. 100% permanent total disabled vet. I'll have to be filing soon to PTSD, flat feet, and urinary issues. I will tell you, Jake, my experience has been that PTSD is difficult. For some reason, Social Security judges seem to discount military-based PTSD. Again, I've had cases where I've had clients who were in combat for a year in Afghanistan or Iraq, had IEDs exploding, people they knew getting killed, people shooting at them, never could really rest completely for a year and a half. Judges just seem to think, well, that just goes with the territory of being a soldier. And not every judge, but some do. So it's really, you have to have symptoms, to the degree where, let's say that, what they expect to see would be that you enter into a room, you always want to be hyper vigilant. You're always looking around to make sure that nobody's behind you, that, loud noises, you might dive for cover if you hear a car backfire or if you hear a siren. It's got to really manifest itself in some really, work preclusive, disabling ways. Maybe you've got, of course, PTSD is an anxiety disorder that, you may have episodes where you're non-functional for a couple of days. And again, treatment from the VA is fine, but private psychologists would probably be better. So it's a hard road if you're going PTSD. Some judges just seem to think it's like I said, part of the territory. I don't know. Flat feet, that will eliminate jobs where you'd be walking 6 hours a day. So that might help there. You don't say how old you are. If you're over 50, over 55, now you get into the grid rules. The urinary issues could be the winner. I win a lot of cases on people who have urinary incontinence, urinary urgency, frequency, because that's going to take you away from the work site. So I win a lot of cases with irritable bowel disease and with urinary incontinence issues, things like that, because it is really going to negatively impact you in a job. Randall Reed, nice picture there, Randall. He was approved in 2020. The judge set review 5 to 7 years. Should I expect a review next year? If so, how to prepare? They tell you 5 to 7 years doesn't mean it's going to happen. I think you should be prepared for it. I would say, the number one thing they look at would be, are you continuing to go to the doctor, and are you getting treatment for the same conditions that were disabling to you? If let's say you have back problems, you're getting epidurals, physical therapy, have you had surgery, that kind of thing. What is your condition now? You're older, obviously, now, but what is your condition? So that would be one thing they look for. The second thing they look for is earnings. Have you tried to work? Are you working part-time? That can make a difference. But I think that the medical is always a big issue in Social Security. So if you have ongoing medical treatment that continues to show that you still have a high level of symptomology, whether it's pain or problems focusing or remembering, and limitation of movement, that's going to bode you. That's going to make things work well for you in the CDR. And if you are now, in a grid rule category, so let's say that you were approved, you were 48, now it's 5 years later, you're 53. Well, the sedentary grids apply, or maybe if you're 55 or 56, the light grids apply. So you can apply the grids in a review if you should get that far, even if they were not applicable when you originally filed. But again, keep in mind that the main issue is your capacity to be a reliable employee, Randall. Oh, thank you, Jake. I'm glad that you find the videos helpful. And I'm glad you tuned in. Thank you very much. Nathan Pedroza said files. I don't know what that means. Okay. Sheila says, thank you. Thank you. Well, Sheila, I've got a note to have Jen call you. Jen, if you're out there, call Sheila. I was approved for depression, then got better. No need for it any longer. I recently applied because of depression. What are my chances of getting approved again? I think it bodes well if you were on disability for a medical problem, then you got off of disability because that medical problem improved and now it's taken a turn for the worse. The fact that you told them that you wanted to stop receiving benefits, I think it shows that you're honest and that you're a person of character. I think that will help you. Again, the medical still also supports you, but if you got in front of the judge and you said, look, judge, when I was feeling better, I got off benefits, I went back to work, I did all these things, and now it's come back, a judge is going to be more likely to say, I accept, I believe what you're telling me. Thank you very much. I don't know if I'm the best lawyer on YouTube. I'm prolific, I will say that, but I try to share what I know, and I'm sure there are a lot of people who are know a lot more about other areas of law than I do, or maybe in Social Security, but I try to share what I know and try to be as accurate as possible. But thank you for the kind words. I really do appreciate it. Okay, Kimberly says, what do I look for? My result report from the FCE is requested by your pain management doctor. Well, I think that if you look at an FCE report, and I've looked at plenty of them, the first page or two will say that the FCE report, the conclusion is that you're limited to sedentary work with the following limitations, light work with the following limitations. So you want to look for the conclusions, and then you want to look for anything that talks about your capacity. If it's a physical CE, you're lifting, you're sitting, you're standing, you're walking, bending, kneeling, crouching, crawling, stooping, all those kind of things. And if you go to one of these sites, and I always give this example, the How to Get On site, which is, let me just put that link in the notes, and then this is the James. Let's see here. That must be the Oliver one. Okay, that was the video. Okay, so here is a site about free functional capacity forms. Here's another one. What I would probably tell you to do is, get one of these forms that's applicable to you in terms of your physical condition, and then fill it in based on what the FCE report says. And if you're fortunate, you can get your doctor to sign off on it because it reflects the narrative. Of course, the FCE report itself would be evidence, and you can submit that. And again, if it says that you're limited to sedentary, or whatever it may be, then that would become evidence. Now, realize that these FCE reports may be only going to focus on your back problem or maybe your knee problem. They may not focus on your anxiety, your PTSD, your depression, your breathing problems, things like that. So if there's other things going on in addition to what the FCE report is about, you would add to the FCE limitations accordingly and make that argument, or your attorney would make that argument in court. Okay, that review guy filed in February of 23, got denied. Now in recon, went to one CE exam and initial, and they went 2 more C's at recon. They did a claim for months. People ask me that, do the adjudicators, why do they send me to consultative evaluations? One, they've already sent me to one before. Number two is I didn't allege depression, but they sent me to a psychologist. So the answer to it is that Social Security has an obligation to develop the record. That is part of the law. And so the CEs, the courts have said that sending somebody out for a consultative is sufficient effort by Social Security, the administration, to develop the medical record. Obviously, the judge can weigh that report however he or she wants, but that it satisfies Social Security's burden to develop the record. So that's one thing. And the second thing is that the adjudicator at recon may have felt that the report from the initial doctor or initial application CE doctor was not detailed enough. They may send you back to that same doctor. They may send you to somebody else. Again, if they sense if your family doctor is giving you some sort of antidepressant, they may send you out for a psych CE. My experience has been that the psych CEs rarely hurt you. The physical exam will either be neutral or slightly harmful, but it's rarely going to be enough to kill your case, rarely going to be enough to win your case. I think that the psych CEs are more likely to have a greater impact for you. But as far as the time frame, it just depends on when they get it out. There's no rhyme or reason to it. All right, Vic says, if you have more than 2,000 in your account, does that apply for SSDI? No, only applies for SSI. You can have $1 million in your bank account for SSDI. It doesn't affect you. C exams were a couple months ago. Yeah, and again, you want to try to get a look at them if you can, make some notes as to what happened. It may take Social Security 3, 4, 5 months to go ahead and make a decision even after receiving those, because it's got to go through a lot of people's hands. All right, Daryl says he was denied at recon, filed for an eligibility hearing, and the case was sent back to recon, waiting 7 months. Why would they send it back? The main reason it might be sent back would be that in your request for a hearing, you suggested or referenced a new medical condition. A judge or many hearing officers take the position that, the recon and initial are the people who are going to make a decision about, evaluating your new condition. Is it severe? Is it debilitating? That kind of thing. That's the number one reason they may send it back, would be the file needs more development to get to the point where it will be ready for a judge. Judges do not like to look at something brand new that has not been previously developed. That's probably why. All right, I got a very nice donation from, let's see who this is, Damari Robinson. Okay, thank you, Damari. He's 45, has had anterior fusion surgery a year ago. Let's see if I can get this on the screen here. Put you at the front of the list here. Here we go. Okay. Had degenerative disc disease of lower back. My hearing is next week. My chance is good. I have an attorney. I'm also a disabled veteran. I would say this. I think that anytime you have surgery, a fusion surgery, that suggests a significant problem. They don't go do back surgery, unless you've got a significant problem. And degenerative disc disease is typically going to go along with that. When you have a fusion, obviously it puts more stress on the discs above and below where you have the fusion. So I think, but the fact that you had a surgery does not make you disabled. The fact that you've got degenerative disc disease or a herniated disc does not make you disabled. What you really need to ask your doctor is, what limitations would he or she put on you, by virtue of your back problems, by virtue of having, did you have any complications post-surgery? Do you have limitations on lifting, carrying, standing, sitting, walking, kneeling, crouching, stooping, things like that? You want to identify very specific limitations that have arisen from your surgery. Maybe some things are better. Maybe you have pain, a different kind of pain. Maybe again, you've got referred pain where it's no longer in your back, but now it's in your hips, your knees, things like that. So I think that you really want to focus on the specific reasons why you would not be reliable. Being a disabled veteran will get you faster, but it will not be binding on Social Security. Now, I just did an appeal. We talked about appeals before, and I had a client who was turned down, 100% disabled veteran, and the judge didn't mention it in the decision. So there are a couple other problems, but I put in there when I did the appeal is that the ALJ failed to address the claimant's 100% permanent total disability by the VA, and while it's not binding, what weight he did give to this, what relevance it had in the judge's mind. He didn't mention it. I think that could be an error. So, but anyway, but I think to get to Damari's question, I think being a disabled vet, if you're 100%, that is something that should be considered and by the judge, but it's not going to be binding on it. But I think the bigger issue is, what are the very specific medical issues, functional issues that have arisen from your back surgery, both before and after the surgery. So you can almost break this down into, let's say you had the surgery in April of 2024, your onset day was October of 22. So you have a period of time from October of 22 through, April, May, June of 24. How was your back then? And then if it's gotten better, is this a closed period you could go for? Are there different issues going on? So I think you want to address that. But I think the main thing to talk to your lawyer about are the functional limitations that have arisen. That is really, really important to just to really help the judge understand what's going on, because that's the main issue. That's the main issue. All right, let's go back up here. Let's see. This is a person about the consultatives, $2,000. Why was the case sent back to recon? That was another question there. Okay. Is it true that attorney fees get more complicated when cases are taken to district court? Please explain that. Okay. And this doesn't happen a lot, but I will explain it. There is something called a 406B fee. And basically, the way this works is, generally speaking, when you hire a disability lawyer, we can charge using one of two procedures. One is something called a fee agreement, where we agree to a fee of 25% of past due benefits with a cap. The cap is currently $7,200. It will be moved up to $9,200, I believe, in December. But right now it's $7,200. So with that, we don't have to break down our hours. We don't have to show what we did. It's basically just, it's a contingency fee, no upfront cost. Social Security's decided that that's a reasonable fee. Or we can do what is called a fee petition, where we actually keep our hours and submit a hourly breakdown. It could be 3, 4, 5 pages of all the things that we did to a judge and have the judge approve it. They will only withhold 25%. But if, let's say that the 25%, let's say that the 25%, straight 25% was, $4,000, and the, and the fee agreement, the hourly breakdown was for $9,000. Assuming the $9,000 is, no more than 25% of the total past due, the judge could approve a fee of $9,000. Most attorneys will do the fee agreement because it's simple, it's easy, and it's fast. However, most of the time, most of the fee agreements, the standard fee agreement, which is a form 1693, basically say that if the case goes to court, appeals council or district court, that fee agreement is null and void and you have to enter into something else. Well, if the case goes to federal court, and again, I usually associate people on this because they're set up to do litigation that I'm not set up to do. After they do the case, they can ask for what is called a 406B fee, where they're basically asking Social Security to withhold a flat 25%, no cap on it, for the work being done based on the, underlying ALJ appeal, appeals council, district court, the remand back to the ALJ hearing. And they can ask for the 406B fee, which is a flat 25%. So that's when the fee can be more than the cap. And I probably have had 4 or 5 of those, in the last 10 plus years. We'll do the 406B fee. And again, if I'm doing 2 hearings, the case is taking 5 years, that's why it's a lot of work. And of course I split that. I have if I have a co-counsel, we split the 406B fee. It's not, both of us are not getting the same amount. It's, I may get more or less depending on who did more or less, but that's what we're talking about there. And that, by the way, is why I will not get involved in a case if somebody's already had an attorney, because if they have a previous attorney, that attorney will not withdraw and waive fees, then I got to file a fee petition. Social Security does not put any effort into processing fee petitions at all. They will sit there for years. I just got paid on a case last week. I did the hearing, I want to say 2020. I had to, I filed fee petitions. I called. I put, I don't know how many hours into trying to collect my fee. And my client actually, there was a form, my client actually signed off on it. Like, yes, he did the work, pay him. And it still took, 4+ years. So I stay away from fee petitions myself. Okay. All right. That review guy is basically saying, okay. That review guy is basically, I got my watch back, so I'm just looking at texting coming in. My family they're all texting about something. I don't really know. Maybe the debate. I don't know. They can't make their mind up with 3 exams on a pain management and primary doctor. I don't want to even guess as to why they keep sending you out to these things. I just don't know. That's just something they do, and sometimes there's no rhyme or reason to it. So I will not hazard a guess. But yeah, it is frustrating when they don't seem to want to make their mind up. You've got treating doctors who've given opinions. They keep sending you out. It's almost like they're looking for a reason to turn you down. Maybe that's going on. David, who had very nice words from you before. I'm 53. By the way, David, just as an aside, the picture you've got there shows you, I'm assuming it's you, doing scuba diving. I would change that picture, silly as it may sound, because if a Social Security judge was, just doing a little independent research, what they're not supposed to do, but they do it anyway, and they came across your Facebook profile and it shows you scuba diving and you've got back problems, I think that's just you want to eliminate that factor. Just, until the case is over, just get a D, get an S or something like that. Just something or a picture that doesn't show you doing something active. Just my 2 cents. Why give them more ammunition? 53. They want to see if you can do your same job. Step 4, can you return to past relevant work? You've had to be self-employed. How can I tell me to start soon? Self-employed, again, I think what they're going to be looking for is they're going to classify that self-employment in terms of kind of what you did. If you were in sales, were you in IT, were you in marketing, were you a numbers guy? So they'll kind of make big categories. So let's say they classify your job, you were in industrial sales. Let's say you sold, I don't know, parts for, scaffolding of some type. I'm just making that up. So that's what they're going to say is, could you go back to doing something like that? And also as a self-employed person, the skills you might have picked up, maybe some accounting, bookkeeping, filing taxes, handling with personnel, dispatching. There's all kind of things that would arise from the skills that you may have acquired as a self-employed person. And those would be things that could theoretically transfer to something generally the same, but with less physical limitations. So let's say you went from working in a trucking company where there was some physical parts to it to working, in a flower distribution center where there was no lifting or carrying. You were just the back end. So that's what it was. So I don't think it's that self-employed people are getting screwed. I just think that they're going to classify you kind of generally as far as what you did and your self-employment, and kind of put it in the same box as if you had a job, and that's what they're going to do here. And the review guy says seeing a specialist, and again, it may just be that they felt like there was no specialist who had actually seen you, and so they want to send you out for a consultative, a neurologist, a neurosurgeon, or orthopedist, something like that. And St. Louis Grand bought a super sticker for $3. Thank you very much. I really appreciate it. That is much appreciated. Thank you, St. Louis. Johnny Doster. Johnny's here a lot. Did we get any damage watching the Braves postseason play? The Braves, if you didn't know, had a horrendous year with injuries. I mean, the first week of the season, they lost their best pitcher, this guy Spencer Strider, and then they lost, one of their best hitters. They had injuries all season long. They just had people going down one after the other, and the Braves have been good for a long time, and they just kept fighting and fighting and fighting. It came down to the last week of the season where they were like in a three-way tie with the Mets, the hated Mets, Arizona, and the Braves. And so the Braves had to win 1 out of 2 games in a doubleheader yesterday. And the first game, they were down, they were up, they had the lead like in the 9th inning or something, and they lost it. Lost the first game of the doubleheader. They won the second game like 3-0 or something like that. So it was I was actually not even watching. I was at a meeting. I belong to a book club, so my book club had a meeting last night, so we had it on the background, but I wouldn't pay that much attention to it. I just felt like this is one of these years that the Braves, if they got in the playoffs, which they're in, they're going to have a hard time. Although, interestingly enough, if you're a baseball fan, teams that have been clinched the division, they've been kind of not using their top players and putting in the subs for 2 or 3 weeks or whatever. And I think they're playing San Diego. I'm not sure if that's the case for San Diego, but they kind of lose their edge. And that's happened to the Braves a couple of times, whereas a team that's been playing every single day, that's just, kind of in that zone, they can sometimes pull an upset. So it'll be interesting to see what happens. But it can be very, very, we used to call it Braves fatigue factor, where people would watch the Braves till, midnight or something. They would win the game in the 9th inning or something, back in the 90s and all that. But, they're a gritty team. They got a lot of, one guy goes down, they get somebody else replace him. So, but it can put your stomach in a knot. Of course, the Falcons won a football game on a last minute, like 58-yard field goal by Younghoe Koo with 2 seconds remaining. And then I don't know what they were thinking. They kicked the ball. Anyway, they ended up winning. University of Georgia lost. They were up, they were behind the whole game. They lost after they were up with like 2 minutes to go, and they managed to let a guy, score a touchdown. So, it's very stressful to be a sports fan here in Atlanta. And as far as damage, I did not personally, but I know a lot of people here did. There was some video of flooding in areas that I know. I used to live in those areas. In fact, I used to live in a house that I grew up in right near a creek. And when it would flood, my house was like 2 houses away from the creek. We were technically in a floodplain, and it would occasionally get to my house and flood our basement, maybe 3 or 4 times when I was a child. So it's flooding is not fun because it causes obviously mold and all kind of crazy stuff. Jarius asks, does SSA normally have claimants complete the medication form at the beginning or the end? Both. They want to know at the beginning and before the hearing. There's a series of 3 forms they will send you: a medication list, a work history form, and a recent medical treatment. But they're going to want to see the medication list at the beginning and at the end. Okay. Greetings, J Money. Okay. Now I'm J Money. No one's ever called me J Money before. I'm too old to be J Money. Let's face it. Come on. Despite, this camera smooths things out. I'm not really this young as it looks. I mean, I'm not going to tell you how, complain about it, but not quite this young. You see the gray there? That's gray. Okay. Although I still am pretty effective in the tennis court. I got to tell you, I had a match last week. I had to play line one, which is we have 5 lines. And line one is the top players, and I normally play line 2 or 3. And my normal line one wasn't able to play, so I had to step in and play doubles. And I actually did pretty well. I've been working at it, and I did pretty well. So for an old guy, I can, not too bad. So I'm pretty happy with that. Not that I'm bragging about it, but just so in case you were interested. All right. Greetings. I had that young ALJ disability hearing July 24th in New York. No decision. Well, it's July 25th. We're in October. I mean, you should be hearing something the next couple of weeks, but you're not outside of the zone of reasonableness. Okay, I would say. But you should hear something soon. Hopefully next week or two. Crystal says, my son receives SSI. Will his benefits be affected if I receive disability too? He's 16. You represent a pay. He had lower back surgery along with other issues. It could be affected. What you might want to do, and again, this is a little beyond what my practice area, but you might want to talk to an attorney that maybe could set up a special needs trust for him so that money would be going into a trust for his benefit. So it would not, your receiving benefits would not impact him. So, and of course, he would be eligible for auxiliary benefits while he's still a dependent, presumably. But I would talk to a lawyer maybe about doing a special needs trust or just to see what the options might that be. This might also be a question that you can ask Greg Brinkley, Greg at gregbrinkley.org. He deals with that kind of stuff more than me, and he might be able to answer that questions for you. So reach out to Greg at GREG at gregbrinkley, BRINKLEY.org, and see what he tells you, he has to say about that. Because he used to work in the back end Social Security. Okay. Nick says, I really like it if Ginsberg representative former Michigan, not taking cases. I am taking cases, but what happens is if I get overwhelmed, there are 3 or 4 attorneys around the country that I do a lot of work with that we refer back and forth. And so if I am just too tied up to take on anything, I got 7 hearings coming the next couple of weeks, whatever, I may refer it out. I'll take a look at yours again. Let me make a note of that one. But if I send you someplace, it's somebody who knows what they're doing. And the guy in Michigan, Joe Hoyle, or Hewell, I think is how he pronounces it, is pretty sharp guy. We've dealt with each other for a long time. But let me look at it. Nick Greasy. And I'll reach out to you tomorrow, Nick. How about that? Okay, JC Sports. Thank you. My pleasure. Christina, my California person, is here today. Okay, now we got nice. Okay. Flattery will get you everywhere. Another question: if my SSD turns for retirement, can I live outside the U.S. for 6 months? It depends on where you go. If you look up if you just type in, where can I collect Social Security overseas? It will give you a list of countries where it's not a problem and a list of countries where it is a problem. Don't go to North Korea. You can't get it there. Don't go to Iran. Not going to get it there. But there are other places, go to England or France or Germany, you can get it there. A lot of places in Latin America can get it, but you need to look up the country. That's really the big question. All right, if a claimant was denied at 52, all prior work removed, RFC, reduced light work, no transferable skills, or go down approval at 55. Very likely, yeah. I think that many times people that are denied at 52 because they're limited to light work, and then you refile the case and you go to another hearing and you say, well, the last hearing the judge found that he was limited to light work, reduced range of light work. He grids out now. And the judge will say, yep, you grid out. So if the analysis has already been done, you can use that as, what they call res judicata or collateral estoppel, basically where a thing has already been decided and that, they're not going to look at it and say, well, we're going to decide now you could do medium work. So I think you'd have a pretty good argument there. Okay. I know you're aware I need your help. God is good. I'm not sure if I quite understand the question, but okay. Johnny, I'm currently working right now, but at times it gets so busy I can't keep up with intellectual disability. Can I get my manager write a letter to help my case? Yeah, I think that, if you're working below SGA level or you're getting extra help, structured work setting, things like that are not in line with what they call competitive work, that you're getting more help than somebody else would get at a similar type of job. I think your manager could write a letter. That's non-medical evidence. It would be very, very helpful. Absolutely. Thank you, Christina. Always there to remind people to like and subscribe. Let me go ahead and put this. I've got a little another banner here. Enjoy the life. So leave me a review. Please do that. I would really appreciate it. It's always, always, always appreciated. And yes, thank you very much. Leave me a review. Yeah, reviews. I actually got. I think I may have told you all last week. I got a bad one the other day. Somebody was really unhappy about. I don't really know what they were unhappy about there, that I referred them out for. It was maybe a case that the person had got an unfavorable decision. I gave them names of 3 or 4 lawyers who did appeals. It just wasn't something I was interested in. And this person got upset about it and gave me a 1-star review. I'm like, okay, what are you going to do? But, I like to, obviously and actually it's not the end of the world, because I think it shows to the general public that these are not fake. These are people really leaving reviews. But sometimes just, and of course I'm not going to say anything bad. I'm just going to say, I can't take every case. I don't have the bandwidth for it. So if I refer it out, it's because I just don't have the bandwidth. I'd rather you get to somebody quickly as opposed to waiting for me. Or it's just maybe not a case that I feel, has a good chance at winning. And again, I'm not going to lie to you. I only get paid if I win. So if somebody, reaches out to me and they're 30 years old and they've got a broken pinky, there's not enough there. And I know there's not enough there. So I'm not going to waste my time or theirs or Social Security's in that situation. So I've got to limit myself to cases where I think reasonable chance of winning and I believe the person. Jose says, I just got awarded. Why is it the payment tab is SS active, SS suspended? Yes. The answer is that SSDI offsets SSI. So let SSI, the most you're going to get is like $980 a month. SSDI is going to, let's say, $2,000 a month. Every month you get SSDI. So what they do is they say, okay, you're qualified, you applied for both. And maybe during the 5-month waiting period, you get some SSI. But once the SSDI kicks in, it offsets dollar for dollar the SSI. You don't get both. You get the higher of the two. So because SSDI offsets the SSI, there's no SSI anymore. So they grant you SSI. Then the next day they send you a letter saying you don't get it because it's being offset by SSDI. And that's the reason why. So SSDI is going to be active. SSI would not be. T-Cash finally got approved. They sent me back pay $26,000. My attorney got $6,000. Well, I get a 1099 for the entire amount. I'll have to pay taxes on it. I think you only get a 1099 for what you actually get. And as far as taxes, that is a question I get a lot. If you type in, there's a pretty good NOLO article about taxes. Let me see if I can find it real quick. Taxes and SSDI. It really depends. It's actually a Social Security article too. So there is a article here from the Social Security website, and I will give you a link to that. And it basically says that if your household income exceeds $32,000 or your individual income, you get paid taxes up to 85% of your Social Security benefits, not SSI, but SSDI. So, it just depends on how much you generate total from SSDI, and they would, possibly tax you up to 85% of it. I've never understood why they tax anything for Social Security disability. I mean, this doesn't make any sense to me. This is tax money you've already been taxed on. So they're taxing you again on money you've already been taxed on, and you're disabled. Why are they coming after you? I don't get it. But so the $26,000, I think you just need to talk to a tax preparer like H&R Block or something, and they can do the calculation real quick. But if you have to pay taxes on it, it may be for 1 year, but probably not after that. Good question, SD. What happens if I refuse treatment that has side effects and I meet the criteria for those that would be affected by that side effect? Would they be okay with me explaining that? Yeah, I think that if you refuse a treatment that causes severe side effects, then that will not be held against you. So let's say that you have a condition that would make you more functional if you took a drug that had carcinogenic properties and you said, I'm not taking it because I don't want to develop cancer. By not taking it, your symptoms were magnified to the point where they were disabling. That would not prevent you from getting benefits. Your doctor says you need to have a fusion, but there's a possibility you could end up paralyzed. No, thank you. They will not hold that against you. That is a ruling, but you have to be able to explain why, specifically the side effects, the danger. Just, arbitrarily, I don't want to have surgery. I don't want to take the medicine. Not enough. You have to have a reason for it, which I think you do. Okay, I think we already answered that one here. Alice says, thank you. You're welcome, Alice. This is the John Oliver video there. I think when I clicked before, it did not come up. Okay, these are the functional capacity forms there. Kimmy, favorite best lawyer. Okay, thank you, Kimmy. Very helpful. Thank you so much. Well, I really appreciate you taking the time to watch and to make that comment. Thank you. Really appreciate it. Leave me a review. You can leave a review about the live stream. That you thought that was useful. I'd appreciate that. Let me put the case eval back on here. I got this software called StreamYard, which is web-based. And actually, when I first started doing this, I used a device called a YOLO box, which I still have. I probably should just sell it. But YOLO box is really more designed for remote. Like you could do it from let's say a ball game, a football game or soccer game or something like that. And you can have like 5 or 6 cameras coming into it. Very, very versatile thing. And originally I thought that's what I needed, but I just have one camera. And the thing about StreamYard, which is nice, is I just I have this new webcam, which I talked about before. I think is really nice. It's everything is online. It's web-based and it's really easy to use, and it's pretty reasonably priced. And why not? So that's what I'm using. Okay. All right. In Atlanta, Georgia, as am I. You have a general estimate how long may take in reconsideration after my CE mental and general mix. Recon in general takes 8 to 10 months. Depending on where you're at in Georgia, that's about what we're seeing, 8 to 10 months. I do cases all over, not just in Georgia, but a percentage of my cases are in Georgia. But I think 8 to 10 months total is a pretty good estimate. How long should it take them to review it and give a yes or an answer you know about? Again, 8 to 10 months total, I would say. This is Damari again, who I think we've answered his question, I believe. Are you disabled? That is the main question in a disability case. Awaiting a new hearing, post-appeals council remand will have to test. Yes, you'll have a whole nother hearing. So it'll go back to the same judge, which is ridiculous to me. Christina says, Christina, my regular, if somebody's applying for SSDI and SSI in California, how long does it take for the initial California? I'm seeing a little longer, probably closer to 12 months. It's pretty backlogged in California, so I would tell you it's longer. Texas, California, and Florida seem to be the worst states right now. That's just my experience, so I would tell you probably a year. But, like we had a gentleman who got was at a hearing in 45 days, so. Okay. Al makes a point about Damari Robinson, who's the 45-year-old with bad back issues, had surgery, having a phone hearing, and she's like, well, maybe you should have a in-person hearing. Judges are not really allowed to. There's actually law that says they cannot look at somebody and make a decision based on how they look, positively or negatively. Now, I used to, when I did live hearings, when I do them, my practice is always let my client walk in kind of alone so the judge can see him or her. And if they're walking with a limp or using a cane or something like that, I think judges are human beings and it can be effective. But, they're not, there's something, they call it sit and squirm jurisdiction. A judge is not really allowed to say, well, at the hearing, this person was moving around, they were clearly in pain, therefore I think they're in pain. That's kind of a medical opinion. So I think the medical, and I've said this before, the medical evidence is about 85% of whether you win or lose. I think your testimony maybe about 10% or so, and then your lawyer's brilliance about 5%. Really what we're there to do is to make sure the case is prepared, to give the judge some assistance, trying to find things if they need it quickly, keeping the client calm and asking questions. But, the work is done ahead of time, really, at least for me. Sir Campbell, working on third filing in 2021, D.H. worth case, I pay 2 years of back pay. I don't know. Don't really know what you're asking me, Sir Campbell. Maybe you could rephrase. Luke says you like this shirt. I think I realized I wore the same shirt last week. This is actually my wife got this for me. I got to admit, I don't know. My wife knows more about the clothes I own than I do. I don't know. Mostly a t-shirt and shorts that's what I know. If I got to go out, I have some suits, obviously, but I try to wear a nice shirt for the live streams as opposed to a t-shirt. But this is one, it's got a whale on there or something, I don't know. But it's got little snaps on there. Not that I can't do buttons, but this one has snaps. So, it's a summer shirt, so it's light. And first thing I saw, and I jumped in the closet, so I grabbed it. But I'm glad you like it. Hello, David. How are you doing? Crystal says, thank you. Do I take cases in Hawaii? I do. I've had several cases in Hawaii. In fact, there is a psychologist that has an office in Hawaii that he does like virtual appointments. And I've used him on several cases for people in Hawaii and out. I had a case out of Hawaii about a year and a half, 2 years ago. We got it approved at like initial. So Hawaii, yeah. And in fact, if I had to do a hearing in person, I'll go out there. It's a bit of a schlep, but no, in all seriousness, yeah, it doesn't matter. Hearings are on my phone or video, it doesn't really matter. So I do cases in California, Arizona, New Mexico, Colorado, Washington State, Oregon. It doesn't really matter. I do them all over. In fact, we have to do this thing where it's called ERAP, or employee, or I don't know, something representative, something or other, availability program. And we have to give them notice as to what days we're available for hearings 6 months in advance. So I just filed the availability for March of 2000, I think it was March of 2025. On September 28th or 29th, I did it. So it tells them what days they can schedule me. So, if, for example, if I have cases in California, so I may schedule 3 or 4 days a month for California hearings, but I may say that these hearings, need to start, whatever time in California, so it doesn't put me in a hearing at 8 o'clock at night, something like that. So, but we have to tell them what days. So that's what I do. But yeah, I do them all in Hawaii, any place, and that's Alaska. I had a case out of Vietnam a few months ago. I have cases in Mexico. I got a guy in Honduras right now. Doesn't matter, really doesn't matter. That's one kind of neat thing about this practice area. It used to be they're all local. Now it's all virtual. Yes, Sachi, you can collect retirement and pursue disability at the same time. I talked about this earlier. You will get your money right away, but it'll be about 75% of your full retirement. If you win disability, you get bumped up to full retirement, as if you were 66 or something. And what you'll get for past due would be the difference between the full and the early. So which may be $500-600 a month, which, as I said before, could limit you in terms of the attorneys that will take it. Because if you choose to get an attorney, because the past due benefit will be, instead of 25% of $2,000 a month times 24 months, it would be 25% of $500 a month times 24 months. So it's a lot less money. But yes, you can do that. Nice, thank you. Thank you very much. Nice, and yes, sir. Okay, yeah, okay. Let's see what this says. That's the article about taxes there. Okay. I got told both my knees are bone on bone. What do you think your chance of getting disability? Well, two things come to mind. Number one, Joel, how old are you? If you are 50 or older, then the grid rules could come into play. If you're bone on bone, you might very well be limited to sedentary work, in which case, the grid rule could apply. If you're 55 or over, even if you could do light work, you could still be disabled. And so I think bone on bone knee issues would limit you pretty significantly physically. So I think that's one point to make. If you're over 50, then the grids can apply. I think secondly, if you're under 50, again, it's always going to be harder if you're under 50, but if you are, bone on bone suggests it's very painful. Your walking is limited. And, if you're on pain meds and you're in severe pain anyway, that might be grounds to say that your capacity to be a reliable employee has been so reduced by the knee pain that you would not be able to be reliable at a job. That's the functional capacity argument. So again, you don't win based on, a diagnosis. You win based on the effect of your medical problem on your capacity to work. So you would need to explain why having bone-on-bone knees is preventing you from working. SD says, thank you again. Okay. You're welcome. Rahul Hoke, I'm not sure if I'm pronouncing that right. Rahul. My x-ray came back and I have scoliosis in my back. Taking out my claim, but denied 3 times, getting a lawyer, waiting for a court. Well, scoliosis obviously is a curvature of the spine. Severe scoliosis, I have one cases. I had a young lady one time who was actually in college, and she had severe scoliosis where she had trouble walking. That was enough to win. Usually scoliosis will be in addition to other things, so it can certainly limit you physically. The question is, how bad is it and how limited are you? I charge 25% of past due benefits with a cap right now of $7,200, so there's no upfront cost. But again, I'm also very selective because, I only get paid if I win. So that's what I charge. And what I tell people is, if I can't help you, I know a bunch of other attorneys who can. And if I can't do it, I'll refer you to somebody who can help. Speaking of baseball, the Red Sox struck out. Yeah, I hear you on that. I always like the Red Sox, especially the Pedro Martinez and Big Papi and what's his name, the other guy, I can't remember, the crazy guy who was always Manny Ramirez. I like that era, and I remember when they won the series, they beat the Yankees. I always kind of like the Red Sox. They just always kind of in the Yankees shadow, and they finally kind of escaped it. And I think they had a real good team for a long time. But I'm a Braves fan. I mean, I grew up in Atlanta, suffered through the Braves, many losing seasons, and then in 1991, the worst of first year, they've been pretty competitive ever since. You're welcome, Christina. Listening, I always thought the opposite. I don't remember what we were talking about, but look, I could be wrong. I'll flat out tell you, but I think that I remember something you said, and I think, yeah, that's just me. Look, whenever I give you my take, it's my take. I'm not, I don't speak for Social Security. With the doc strike, yeah, I think they'll figure out a way to get it settled. There's a lot of political impetus to do that, so I don't think they'll be striking that long. Congress had to go, yeah. No, I mean, it sounds like you did what I tell a lot of people to do, is to reach out to their senator or representative. I mean, here in Georgia, we have John Ossoff and Raphael Warnock. Actually, I find Ossoff's office is very responsive. Really haven't done much with Warnock's office, but Senator Ossoff, to his credit, has been very responsive. He's got some good people there, and they'll follow up. So yeah, it sounds like that's what you did. How long after they've had everything reviewed do I get your decision? Again, I can only tell you that in Georgia, 8 to 12 months is pretty typical. Robert, how are you doing, Robert? Yeah. Okay. Good. Yes, we got I know we emailed back and forth, and then I think yeah we got all your information. I appreciate that very much. Look, a lot. You'd be surprised how often people don't give us that stuff, and you did, which I really appreciate that. So thank you. Main event. The cola. I have not heard anything. Let me see if there's anything over here. What the cola is going to be. I don't see. Let me do a quick search here. Don't know. Don't know. Let's see if this is, let's just see, let's see, Social Security COLA. Um, I mean, it says on just a general web search, it says it'll be announced in October, and it's expected to be higher than average. So it says it will be announced very soon, but they haven't, it says mid-October. We won't know until mid-October. So ask me in a week or two. Robert says, how do we fare in the storm? We didn't have too much problem where I'm at. I mean, again, where I'm in Atlanta, there was, our power did not go out. We're kind of on a high ground, so there was no flooding. There was some branches that got knocked down, but nothing major. My father-in-law did get a hole in his roof. I mean, I think just a leak. It wasn't a hole, just a leak. We had to get that patched. There are some places in Atlanta that had bad flooding. I think Asheville took the brunt of it more so than Atlanta. I think there's some places in South Georgia, northern Florida that got hit pretty hard, but we didn't have much of a problem. So I'm very thankful for that. I Chen, we've seen you before here. Cousin lost, can she apply? Yeah, she can absolutely apply again. Absolutely. David, thank you very much. I really appreciate that. Thank you. Um, I'm not going to, Alex, I'll call you Alex Ortiz because I don't know. I'm not sure how you pronounce your first name, but we'll call you Alex. I started my case in 12224, denied the initial. I'm going to appeal in Puerto Rico. 41, worked 20 years, bank manager, pseudomotor, glaucoma, depression. 41 is going to be the issue. You're young, and you've got you know some medical issues, but what I find is that if you're under 50, it's a real uphill battle. Not impossible, but just an uphill battle. So you're going to need really strong medical support. And they do, by the way, they have the forms in Spanish. They do. You'll be able to do that in Spanish. Low vision, what do you think your chances? Again, I think that it depends on the limitations that the medical report says. The biggest thing in my mind is you're 41. That is just young, and the amount of evidence you need at 41 is, let's say, here. If you were 55, it's here. So you just need a lot more evidence and a lot stronger evidence. So I don't, without looking at it, I can't say what your chances are. I just think that anybody who's 41 has got an uphill battle. You've got an RFC, or functional capacity form, from your neurologist. That will certainly help. Okay. The process. Denied recon. Now the case review. The judge, my first hearing, comment limited to not want legal representation. What was the comment? I'm curious. Did you ever watch the court shows like Judge Middleton live on a certain criminal case? A person SSD looked healthy as a horse, yelling, screaming. I did not. I honestly, I don't watch a lot of TV in general. I mean, I watch some, I watch the Braves. I'll watch some, football games. I'll watch the news occasionally. It's too depressing most of the time. I've seen some of those shows, and obviously they're entertainment. I'm sure they tell people to play it up a little bit, but I suspect. Look, the idea, the image of the person on disability jumping up and down and doing things is good. It's good ratings. You've got a person who's abusing the system. The reality is most people on disability have a hard time getting through one day after the other. So, it's ratings. But I've never seen that. Process of judge was, I don't know we're getting there, but I don't know exactly what you're asking me. Johnny, currently working. Okay, I think we already talked about that one. Lacey Whiteley, what do you do when you didn't appeal for SSDI? Part of disability has been buried to begin immune for this process. Thinking when disability help. Okay, so there are a couple of things. One is, depending on how long it's been, you could ask for good cause. So let's say that you filed for disability, you got a denial notice, but because of a medical issue, psychological issue, you did not appeal it. It's been 2 months. You could file for good cause, and there's a pretty good chance they'd go ahead and process it anyway. If it's been 6 months or more, you're going to have to start over. You can ask them to reopen your prior application. They're not always going to do that, but you could certainly ask them. And I would certainly, the sooner you can reapply, the better. So if you reapply within 1 year of the initial denial, you can ask for reopening for any reason at all. More than a year, you have to show like something really, really substantial, and that's pretty rare to get that. So I think if it's been less than a year since the denial, then you can refile. If it's been only if you're only late by a few weeks or even a couple of months, go ahead and file a good cause request. Use Form 795 when you do it. Main event, thank you, you're welcome. Was blamed for malingering. Was the attorney or you were blamed? I don't know. First Stack decision here in Memphis. Please hear me. The economy today. I'm not sure if what you're saying is that the attorney was accused of malingering or they accused you of malingering. Malingering is a really difficult word in the disability world because if it gets in your record, it tends to stay there. So if you're accused of malingering or drug-seeking behavior or secondary gain, that can, in many cases, really hurt your case. You just want to get those words out of it. You never want to be accused of that. Thank you thank you very much. I appreciate that. Okay. What the judge said, maybe not want to get a lawyer first, probably because it would have taken a long process. Being railroad. So are you saying, okay, Summer, I'm listening to your questions. I will acknowledge your questions. So if you're listening to me, I'm trying to understand what's being said. It sounds to me like that the judge that you're hearing suggested that there was malingering involved, perhaps by you. Why that would encourage you not to get a lawyer, I can't say. That doesn't make a lot of sense to me. If anything, having something like that in your record, you'd want to get an attorney. Well, thank you, Summer. I'm glad you find the videos useful. Rajul is 36 with scoliosis, schizophrenia, back pain, depression, anxiety, but claimed God, but denied 3 times, getting a lawyer for. Yeah, I mean, I think that, again, 36 is the problem. That's really, really young. And, scoliosis, depends on how bad it is. Schizophrenia, actually, people who are younger with some things like schizophrenia, especially if it really impacts your functioning, age may not be as big of a deal, but it's still always hard. But I think that, schizophrenia and anxiety, if it really affects you and it's well documented, that might actually be... might be something that could go through. Okay, Nicholas. Okay, I think I knew that, but I'm glad you told me. Let me go ahead and just make a note of that. All right, so I will pull that tomorrow, and I'll get back to you, Nick. But thank you for letting me know. But I think I kind of somehow, I'm not sure if your emails got that. I remember the greasy part. Summer, yes, I'm going through. Okay, Judge Middleton actually live streams from YouTube from a courthouse in Kalamazoo. Landlord tenant. That's interesting. I think that a lot of these legal shows. Back in the day, we had Judge Wapner. People's Court, and that may be dating me, but that was the show that people used to always talk about, and he would have folks come on and landlord tenant issues or custody issues or child support. Then you got, a bunch of other ones. Judge Judy is a big deal. Then you've got, divorce court and Judge Hatchett and all these different ones, Joe Brown. So they're very popular. I think they're cheap to make, and you get people, there's a lot of tension. There's a lot of, excitement. People are yelling at each other. Yeah, it's a good gig if you can get it. I mean, Judge Judy made millions and millions of dollars doing this thing. I always tell my wife she'd be a good TV judge, because my wife does not put up with any crap from anybody, me included, especially me. Um, but she would be great on these shows, just telling people just to shut the blank up and tell me their story and don't blabber. She's not real patient with stuff like that, so she'd be a good Judge Judy. But her name is Jody, Judge Jody. But so far, she hadn't done it. Nerve damage in the lower extremities, yeah, that can be significant. It can be significant. Um, Nerve damage, nerve conduction issues, makes it hard to walk, to stand, things like that. Lisi Whiteley, I wish my attorney advised me of that. 7 years, I've given up, got put into a box. Um, and the problem, of course, is now you're probably not insured anymore if you haven't been working more than 7 years. So um, that's tough. That's very tough. I think sometimes people give up when they get bad news, and sometimes it's just a matter of just got to be persistent. I have vertigo but undiagnosed, cerebral ataxia. My question will qualify. It depends on the symptoms and how severe they are. I mean, people say I've got this, I've got a herniated disc, I've got diabetes. Well, I can't answer that, because it depends on how severe the condition is and how it affects you in a work environment. That's the best I can tell you. The conditions themselves are things that can be diagnosed, that a doctor can basically say, this is a legitimate condition. That's a good first step. But the question is, having a diagnosis of, anxiety, for example, could be mild to extremely severe. So, and if you're over SGA of 1,550 hours a month, that's a problem. So, you got how severe is your medical issue in terms of how it affects you at work, and B, if you're working, how much are you earning? Could you do a closed period? I don't know. I mean, there's just a lot of questions there. More questions than answers. Teresita, thank you. You're welcome. I'm glad it helps you. Reapply for SSD after I receive partially favorable. Hopefully I get it this time. Again, if you got a partially favorable, it probably means the judge changed the onset date or may give you a closed period. If you reapply, then you do get it. By the way, we have in my office, I haven't really put a lot of effort into this, creating a Spanish language website, but I have 3 bilingual staff people, including a medical doctor. So if anybody out there speaks Spanish that wants a case done, I would have to get a contracted attorney to do it. But in terms of the workup, I have 3 people that, speaks or native Spanish speakers. So just for what that's worth. Our receptionist, Paola, is actually in Mexico City. There's an argument to a VE and you get heated. I don't generally argue with the VEs. I mean, vocational experts. There are some lawyers who take the position that they want to go after the VEs. I've never found that to be something that judges like all that much, so I don't do it. I'm first of all, I choose good cases, so I'm not going to me, if I'm arguing with a VE about the numbers of jobs, for some job they come up with and the source they used, I'm probably going to lose anyway. That's going to be an appeal issue. I mean, if the VE is completely out to lunch, I'll raise that, but I don't argue with VEs. I mean, to a point, I'm not going to let them, if they come up with something ridiculous, if they're obviously biased, but most of the time they're just answering questions for the judge. If it's a new application, again, they can reopen old ones sometimes, but if you're in a current application, it'll be 1 year from the date of your current application if you didn't appeal other ones. So if you reapplied, let's say in 2019, 2020, 2023, then you take the 2023 application, go back 12 months. That's how much you can get. Okay, we're getting close to the end. I want to just take a few more here. Ronald is 55 in November. Well, early happy birthday. Veteran, 100%. Multiple physical illnesses and suffer from chronic PTSD, realization, association, depression, because I'm a veteran, I won't get SSDI. No, I don't think that's the case because you're a veteran. I think it helps that when you turn 55, that will definitely help. Um, I think it's just that, you know, for whatever reason, Social Security seems to have a problem with PTSD cases for veterans, especially younger ones. The physical illnesses might be a stronger argument, or the combined effect of those things. And not every judge feels that way. I don't want to make it seem like every judge in Social Security thinks that veterans with PTSD are faking it. Just tell you, there's enough of them that have turned those cases down, that I just don't really understand why, other than that PTSD is inherently difficult because you can't image it. And I think that, I think there's also a perception the VA just drugs people up and they put them in group therapy and they don't really do much. I don't really know why, but my experience is that there are a certain percentage of judges do not seem to find veterans PTSD cases to be, worthy of granting. Others do, but, I always tell people, if you go to the VA, go to a private doctor as well. That would be helpful. Christina, well, thank you, David. I thank you, David, as well. Okay. Alicia, okay, we'll have time for a couple more here because we're almost at 2 hours. We're just at 2 hours. Alicia's 49, bulging disc and neck, upper back, tailbone hypertension, fibro, asthma, nerve damage, and lower extremities, panic disorder. And, all those things, fibromyalgia is sort of a separate category because it's really hard to win those. A bulging disc, is it impinging on the nerves? Do you have stenosis? How bad is the nerve damage? It's just a matter of degree. And certainly at 50, it will be a little bit easier because you got the grid rules that could come into play. 49, you're close to 50, so you're getting, close to that age limit. But, judges see a lot of cases like this that are kind of mild to moderate in terms of impairments. And, that's a lot of times not enough. I think you would really need good medical support from a doctor, maybe a functional capacity evaluation from a physical therapist that really says why you would not be reliable at any kind of job. And of course, at 50, maybe you meet the grids. So, not impossible, but an uphill battle is what I would say. Wi-Fi Master has a video hearing coming up. No, they do not do criminal background checks. If a VE says your client can work whenever they can't, well, realize that the VE is only answering questions from the judge. So if the judge says, assume an individual limited to light work, no climbing ladders, ropes, and scaffolds, and will be off task 5% of the day, the VE is going to identify jobs. It's not the VE's fault. It's the judge's fault. The judge came up with a question that the VE answers. So the VE is not there to hurt you or help you. The VE is there to answer questions from the judge. The next question is, the person's limited to light work, will be off task 15% of the day, no climbing ladders, ropes, and scaffolds, needs to extend feet when sitting, limited to sitting for no more than 20 minutes at a time. Okay, V is going to say no jobs. So it just depends on the question the judge asks. Okay. Invisible investor in my hospital several times. And again, if there's a reason for that, it's well documented, that would seem to be pretty work preclusive. Yeah, Lisa, it's, you get to a certain point where if you don't have a lot of money to go to the doctor, you're kind of just sort of banging your head against the wall because, you've got something going on, but you don't really have the resources to get a really confirmed diagnosis. You're having symptoms, but, the community health center says, give some sort of nonsense diagnosis. It's really, really hard. I'm getting the sense that money is an issue, and that can make things really, really hard. Does the judge give me a chance? Yeah, you can ask additional questions of the VE. Absolutely. Yep. Thank you, Lisa. I really appreciate your kind words. Okay, we are now at about 2 hours, just over 2 hours. So I'm going to end it right now. I appreciate everybody's attention. Next week, I think we're going to go back to Wednesday. I'll put something out there as I always do. So check back. And again, you've got my, how to contact me here. And because I'm going to put the review thing up here as well. If you did find this useful, please leave me a review. That would be very helpful. If you want a case evaluation, then that's where you do it. So thank you very much, everybody, for your being here. And I wish you all, again, I hope we don't have any more crazy weeks like this with, just strikes and crazy weather and wars and, humanitarians dying and just all kind of nonsense. So hopefully things will calm down a little bit when I see you next week. So everybody have a great evening, and we will talk very, very soon. Bye-bye.